This is Mapp versus Ohio with Paige, Jack, and Megan.
On May 23, 1957, 3 Cleveland police officers arrived at an appellant's residence in the city pursuant to information that a person was hiding out in the home, who was questioned in connection with a recent bombing, and there was a large amount of police paraphernalia being hidden in the home. Upon their arrival at the house, the officers knocked on the door and demanded entrance, but the appellant, after telephoning her attorney, refused to admit them without a search warrant.
You can't come in.
The officers again sought entrance some 3 hours later when 4 or more additional officers arrived on the scene. At least one of the several doors of the house was forcibly opened and the policemen gained admittance. Miss Mapp's attorney arrived, but the officers would permit him neither to see Miss Mapp nor enter the house. She demanded to see the search warrant. A paper claimed to be a warrant was held up by one of the officers. A struggle ensued, but which the officers recovered the piece of paper, and a result of which they handcuffed the appellant because she had been belligerent. The basement of the building and a trunk found therein was searched. The obscene materials for possession of which she ultimately convicted were discovered in the course of that widespread search. At the trial, no search warrant was produced by the prosecution, nor was the failure to produce one explained or accounted for.
The Ohio Supreme Court sustained the conviction even though it was based on the documents obtained in a lawless search. For in Ohio, evidence obtained by an unlawful search and seizure is admissible in a criminal prosecution, at least where it was not taken from the defendant's person by the use of brutal or offensive force against the defendant. For Mapp, the police who possessed no warrant to search Mapp's property had acted improperly by doing so. Any incriminating evidence found during the search should therefore be thrown out of court and her conviction overturned. If the Fourth Amendment did not limit the prerogatives of police on the local and state level, local law enforcement would have a mandate to search wherever, whenever, and whomever they please. The exclusionary rule that applied in federal courts should also be applied to state court proceedings.
For the state of Ohio, even if a search was made without proper authority, the state was not prevented for using the evidence seized because the 14th Amendment does not forbid the admission of evidence obtained by an unreasonable search and seizure. In other words, Ohio argued the 14th Amendment does not guarantee Fourth Amendment protections in the state courts. Furthermore, under the 10th Amendment, states retain their right to operate a separate court system. In a 6-3 decision, the court overturned the conviction. The Supreme Court, in overturning her conviction, declared that the expulsionary rule based on the Fourth Amendment to the Constitution, which prohibits the use in federal court of evidence obtained through an illegal search and seizure, extended also to state courts.
Bye-bye.